Thank you, Mr. Clement. Mr. Katida.
It is a foundational role of this Court, as Justice Kennedy says, to test the lawfulness of tribunals, particularly executive detention, and in the pretrial area. That's the historic role of this Court from Burford to Kieran. This claim Mr. Hamdan's claim is primarily a jurisdictional one, as both courts below found when they recognized his ability to bring this pretrial challenge because he is not an offender under the laws of war until he obtains his Article 5 hearing, because the charge doesn't state a violation of the laws of war, which is itself jurisdictional, and because it doesn't follow the procedures of the laws of war, which this Court in Yamashita at pages 5 and in the dissent at page 72 recognizes jurisdictional. Now,
I don't want to take up from your time, but have you read the footnote that Mr. Clement relies on very heavily?
With respect to conspiracy? Yes, I have. And I do believe the text says that they're referring to domestic offenses. It's certainly the case that conspiracy has been tried as a violation of the laws of war at some point in the Civil War. But that has been entirely eclipsed by the modern laws of war, which have rejected it everywhere. And if you adopt the government's reading, Justice Stevens, that the laws of war are frozen into time in 1916, then I believe there goes the government's case entirely, because the thrust of the government's case is the laws of war have to adapt to this stateless, territorialist organization known as al-Qaeda. If we're playing by 1916 rules, there is no way that this commission would have been accepted in 1916. Now, all of those jurisdictional pretrial challenges were accepted by the courts below when the full panoply of DTA rights existed. Now, the DTA certainly circumscribes the scope. We don't know whether question 1 very clearly is able to be raised after the DTA's enactment. We certainly question 2, as the Solicitor General has said, is not raisable. We don't know when it can be raised because the President can block final review for all time under the DTA. He has the keys to the federal courthouse. And if you defer to this system and give the President the ability to launch all of these tribunals for 75 individuals with these charges, with these procedures, you will be countenancing a huge expansion of military jurisdiction. Conspiracy is one of the few offenses, Justices, that has now been rejected by the laws of war internationally in tribunal after tribunal. It's certainly never been approved by a federal court, and indeed it has been rejected. In Kolpa, for example, no challenge to conspiracy was raised. The government's argument in the end, it seems to me, is one that this Court rejected in Loving, because it depends as its predicate on the idea that the President has ultimate flexibility with respect to these military commissions, except for the 9 provisions in the UCMJ which govern translators and deposition testimony. It is inconceivable that the UCMJ, when enacted, intended to regulate military commissions with only that bare bones to it. Indeed, General Crowder said military commissions and courts-martial follow the same procedures. Finally, Justices, we just point out that the predicate of abstention is not met here. This is not an ordinary criminal trial applying lawful, ordinary procedures. This is an ad hoc trial in which the procedures are all defined with the President. He says the laws of war do not apply when we're talking about protecting this vulnerable individual at Guantanamo, but then he says they do apply and permit him to charge Mr. Hamdan with the one offense which is rejected entirely in international law. It was a great American patriot, Thomas Paine, who warned, "He who that would make his own liberty secure must guard even his enemy from oppression, for if he violates that duty, he establishes a precedent that will reach unto himself." That's what we're asking you to do here, just enforce the lawful uses of military commissions and the historic role of this Court.
Thank you, Counsel. The case is submitted.